Welcome to the Wednesday, March 12th, 2025 Zoning Board of Appeals meeting of the Town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I am now going to do a roll call. David Murch.
Greg Dean.
B. Lockwood.
Fred Miller.
Tom Hennessy.
This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you are unable to see or to hear. The board works from a published agenda and will be considering tonight's items in the following order. Number 1, call to order. Number 2, minutes from January 28th, 2025 and February 3rd. Number 3, old business, applicant Todd Roma and Jessica Dobson. Request for reconsideration of administrative appeal decision. Number 4, code enforcement communications. And number 5, adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks that those attending the meetings with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from any adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that the board record evidences your appearance this evening in opposition and the basis for the opposition. This meeting is not over until the board has formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside the meeting room. Excuse me. Minutes, we have them for January 28th, 2025 meeting, as well as the emergency meeting for February 3rd, 2025. I know Sandy let me know that she corrected a couple of minor typos on the January 28th one, page 2 and page 3. But did anybody have any discussion in regards to this? Any corrections or modifications that need to be made?
No, I don't.
Good. Okay. I'll go ahead then and make a motion to accept the minutes as provided by Sandy outside of corrections of 2 typos.
I'll second that.
Any further discussion? All those in favor, we'll do a roll call vote because Tom is online. David Murch, yes, in favor.
Greg Dean, yes.
B. Lockwood, yes.
Fred Miller, yes.
Tom Hennessy, yes.
Excuse me. Next up is old business. Applicant Todd Roma and Jessica Dobson. Location 141 Raymond Hill Road, map 13, lot 29, zone RR. Description: request for reconsideration of administrative appeal decision dated February 3rd, 2025, of the notice of violation dated October 29th, 2024, land use violation. Excuse me.
Good evening. If I may insert myself at this point?
Yeah, please. I was just going to ask you if you could take us through some of this. So.
Sure. Well, the very first thing I want to say is that your opening remarks about time periods for filing appeals and so forth do not apply to this. There are different time frames for filing an appeal because this is a reconsideration. And in order to figure out the appropriate timeline for appeal, you need to go to the law, and I would suggest the parties consult with their counsel on that. So 45 days is not the correct amount with regard to this particular issue. So this is a reconsideration request, and the board has the inherent authority to reconsider any request within the 45-day period from the vote on the decision. Additionally, a person, an outside party, has the right within 10 days to file a request for reconsideration, which would have the same effect. It's going to the board, and then the board would decide. In this particular case, there are a couple of issues you may need to consider: timeliness of the request, whether you could allow the request to go forward under your own authority if there was incorrect information conveyed to a party about the deadline for filing a request for reconsideration and so forth. So those are all initial considerations.
You walking it back a little?
So the reconsideration itself, the first question that the board would consider is whether to reconsider the prior decision. Whether to reconsider the prior decision is not re-arguing the case. The question is whether there's any significant reason for vacating the prior decision and then engaging in the reconsideration. So the first question is whether to reconsider. It's not a re-argument of the prior case. So what would be a reason for reconsidering a case? Well, it's possible that in some extreme circumstances, there may be true equity and fairness issues that arise because significant information that was not available at the time of the hearing suddenly became available in that 45-day period, or if there's some other irregularity that needs to be addressed. For the most part, you've made your decision, so it's your discretion whether to reopen the case and then decide the case. But the parties, I believe, have appeared tonight and they want to make their spiel. That's completely within your discretion whether to grant it. That's very nutshell, and I'm happy to answer questions as this proceeds.
I do have one question. Obviously, we'll consider the timeliness. If the request for reconsideration were to say to pass the timeliness test, what is the next step? Does the applicant then give us like a quick summary of, or do we go by what's been presented already through documentation? How does that look?
Okay, so if the request is timely, or if you decide to proceed with the question on your own, then you could allow the applicant to speak to explain why he thinks that you should reopen the case. Again, this is not the time to re-argue the case. It's to explain what other factors have come into play that make it inappropriate to let the existing decision stand. So the first question is still going to be whether to reconsider. If the board votes to reconsider, the effect of that would be to vacate the written decision and then set the zoning board back to the position you were right before the vote back on January 28th. So all the evidence is there. You could hear new evidence if you wanted to, and then you can re-argue the case. So the first question is, do you reopen the case? And voting yes doesn't mean that you're granting it, just means that you're reconsidering it. The second question is then the merits of the case. Does that help?
It does. I'm sure we'll have more questions as it goes along. So thank you.
Welcome.
So in regards to the land use ordinance under section 6.3F, it indicates the Board of Appeals may reconsider any decision within 45 days of its prior decision. A request to the board to reconsider a decision must be filed within 10 days of the decision that is to be reconsidered. Vote to reconsider and action taken on that reconsideration must occur and be completed within 45 days of the date of the vote of the original decision. The board may conduct additional hearings and receive additional evidence and testimony. So we received a request for reconsideration from Mr. Roma. We do have to look at the timeliness of it. It was received by the office on February 14th, 2025, Raymond Town Office. There are two essentially dates when it comes to a decision. First date is the date January 28th, for which we as a board voted to deny the appeal. If we go out 10 days from that date, it brings us to February 7th, 2025. Second date that we have to consider for a decision would be the date that the ZBA voted to adopt the findings and conclusions. That date was Monday, February 3rd. If we go 10 days from that date, it brings us to Thursday, February 13th, 2025. So regardless of the date of decision, February 14th goes beyond both February 7th and February 13th. So our ordinances do not allow us to waive or give, consideration to changing that 10-day deadline. So I don't see that there's anything we can do at this point, but at least to consider the timeliness of this request to be untimely. But I bring that for us to discuss. Now, I'll add to this, and in fairness, it is confirmed that the town did inform Mr. Roma that he had 10 business days from the February 3rd date. And if we look at that, that pushes him to Tuesday, February 18th. So given the information that was conveyed to him by the town, which was incorrect, but it was still conveyed to him, he did provide the request for reconsideration in time in regards to that. But based on our ordinances, the request, the way I see it, did come in late. So, and as we've heard from Attorney Hamer, the request from an outside has to be here within 10 days, but we as a board can essentially consider that untimely and potentially deny that request, but then we as a board could also consider the request ourselves. So hopefully that makes sense. If it doesn't, let's ask Attorney Hamer for clarification, but hopefully I'm explaining it well.
If we could, I'd like to just have him chime in again about it,
Yep.
make sure that I'm hearing everything correctly.
Yep. Was there something specific you wanted clarification on, Fred?
No, just on the fact of if that is not met because of the 14th thing, is that really where it stops, or should we reconsider it to the 18th, which you were saying, correct? Because the town gave them a different date?
Yeah, so, Attorney Hamer, why don't you help to explain through, I know for sure our ordinances say 10 days. We as a board do not have the ability to waive that, is my clear understanding.
Yes, that's correct, and your summary was actually quite good, it was accurate. So the board has the inherent authority to reconsider any action on its own authority within 45 days. It's got to complete any review within that 45-day period, but the 10-day limit does not apply to you. So while the applicant may have, for whatever reason, missed the deadline, the board may itself decide to hear him out anyway on your own authority. And it doesn't mean that you have to grant the consideration request, but you have the option of hearing him out.
Okay. So do we need to, Mr. Hamer, do we need to vote on the timeliness at this point, or what's the correct process here?
I'm not sure that there's any need to vote on the timeliness issue.
Okay.
I think that the question is, unless you're going to say that that's it and you're not going to go any further, then I think you vote it's untimely, and then that's the end of the meeting. If you are going to allow any discussion of whether to reconsider, then you just proceed.
Right.
You have that inherent authority.
Okay. So, given that incorrect information was provided, I would like to extend Mr. Roma opportunity to still speak. Does anybody disagree with that?
I just have a question.
Yeah.
So at this point, everything stays the same. We're just going to hear if there's any new evidence for us to make a decision on to rescind what we already have done. But what we've done now still stands, even if they get up and talk, correct?
If I may clarify, yes, your prior decision still stands. The question is still going to be whether to reconsider, whether to reopen the decision. So there's no presenting of evidence at this point. Mr. Roma would be afforded the ability, the opportunity to explain why he thinks that the decision should be vacated and the board should reconsider. So the first question is, do you reconsider? not re-arguing the merits. That would be the second part. And if the answer is, yes, we're going to reconsider, then you move on. And if the answer is no, there's no interest in reconsidering, then that would be, then we'd have a vote to that effect, and that would be the end of it.
Okay. Good. Okay. No objection to having Mr. Roma speak?
No, I think it'd be prudent.
Yep.
I mean, we're here.
Agreed?
I'd like to hear what he has to say.
Okay, Mr. Roma?
Something funny?
Yeah.
Okay.
We can start by speaking to the fact that about us being late to the bringing our letter of reconsideration to the board. We specifically asked you on February 3rd during that meeting, Todd actually asked you 3 different times and asked the town's attorney for clarification on the 10-day window. You specifically said to him, you need to refer that to your own attorney and his interpretation of the law. And then you said, it's up to Sandy. Those were your words. And Sandy chose to accept it 10 business days on February 14th. Now we're here today listening to you, and we got 3 hours ago a letter from CEO Hansen's attorney, just 3 hours ago, saying we missed the window. We didn't hear from Sandy that we missed the window. We didn't hear it on February 14th. We didn't hear it on February 16th when we walked into the town office and talked to her about, is everything in order? She said, yep, we have you on March 12th for the meeting. Everything's all set to go. We got to figure out what you guys are going to have to pay, which we did pay $1,056 is the money the town took from us. And then to have this, letter of reconsideration. So
I'm
even
hoping
during
that
that
you-
time, we still didn't, let us speak. We actually paid good money for this meeting. So at no time did anyone say you missed a deadline, right? Nobody said it until Kathy Plummer's attorney sent a letter. And then all of a sudden, our town's attorney sends us a letter with all the ordinances and all the information. We asked for that from you, from the town. No one gave it to us until Kathy Plummer's attorney said we were late. And then we were late. And then we come in here today and we're still hearing, oh, you missed the deadline. So we'll have to decide whether or not we want to hear from you or not. What are the rules and regulations in this town? I mean, this is really, really disturbing as taxpaying citizens and people who are trying to live our life in this town. Rules and regulations are all over the place. And from our first meeting with you, it was very clear that rules and regulations are all over the place. That's why we asked for reconsideration. And that's why we're here today. So you even, out of your own mouth, just said they were given the wrong information. They were given 10 business days. You even said that. So how are we supposed to know what the rules are if you're telling us the wrong rules? Are we supposed to just pull it out of thin air? I don't understand how you think we're supposed to know these things. Your attorney didn't tell us. You didn't tell us. Sandy didn't tell us. Sandy accepted our information. She took our money. The only reason we found out we were late is because Kathy Plummer's attorney said we were late. And then our town's attorney agreed with her. Can you explain how we're supposed to figure these things out if you guys won't tell us the truth? How?
Is that it?
Yeah.
No.
Now Todd can talk to.
Todd Roma, 141 Raymond Hill Road, Appellant. I'm here because we signed up for a letter of reconsideration because our last meeting was skewed. And for us, it's been skewed for quite a while. We did provide additional information, and again, I'd like to thank Mr. Miller for seeing something in the background. There's been a lot going on that, that does play into us being here. And unfortunately, in the last meeting, there were facts that were accepted that are not accurate. You know, we're talking about the pictures that were set up. We're talking about the timeliness of this. There's a lot of things that are still under question. You know, we showed a picture of an empty tent, and your facts of finding was, unfortunately, Mr. Hennessy threw out at the end, without asking any questions during this time, he threw out the idea of there could be hundreds of people, and this is getting bigger and bigger. There were no facts, nothing to support that. There was a picture of a one porta potty. We're setting it up as one or more. 1 + 0 is 1. There are facts that were just skewed against us on this. I'd go back to the fact that we're working off of a ZBA ruling from years ago where, you know, Mr. Murch, you looked at it twice, but I don't know if you really saw what was behind that, because the ruling just said that our application wasn't accepted, and we left. And then we got a letter from Scott Dvorak unilaterally telling us that we cannot have weddings, any weddings, on our property. And you accept that. There are select boards, zoning boards, planning boards, yet you let Scott Dvorak just go ahead and say, Mr. Roma, you're the only person in the town of Raymond that cannot have any wedding on their property. How does that, what equity is that? How are my rights being infringed upon and no one's batting an eye at it? And it goes back to the fact that we had a poor relationship with the neighbor down back, to which CEO Hansen was friendly and accommodating. And I showed you a picture of, we had to fight for months after our property was torn up. My wife was assaulted. I came to the town for help. We wrote for months and months, and nothing happened. They couldn't even show us a permit until about 7 months later, a lawyer comes back and said, well, CEO Hansen had said that they can do that. He was already in Wyndham at that point. And then at the same time, Scott Dvorak's attitude towards us changed. So all of a sudden we get this unilateral dictate saying that we cannot have weddings on our property. And that's what you've been going by. And that's what's been keeping Kathy Plummer safe and sound. She thought that we cannot have
Any private events
on our property.
Paid, unpaid.
So we do have plenty of information. We did show you the fact that this leads back to CEO Hansen's. He and Floyd Brown, the contractor, he was fine about throwing out the fact that my buddy Chris. So yeah, we do have a very strong connection there. And then it goes over to the other dot, which is Kathy Plummer and our family used to get along well. And then something changed. And then lo and behold, Floyd Brown is then building the facility for her son. And since then, she has not been welcoming at all. She's been fighting this tooth and nail. We've been, every one of these occasions, we've got Kathy's legal team against us. I know you don't want to draw those 2 points together, but there is a really strong connection. Because after we were told that we can't, that our town got, like our property got torn up, Floyd Brown is then working for the town, renovating the town hall. He then also did some work on Mill Street last year. He's done like 4 jobs for the town. And yet, that's fine, you're hiring him and all, but don't give him the preferential treatment. We're paying the same taxes. I'm paying the same taxes that Kathy Plummer is. Why am I not getting any representation?
And if you've read what we sent you, if you did, you will see that our land was torn up. There were clear-cut land use violations. We begged the town for help. We begged them for help. We begged Don Willard. He ignored every email we sent, every email, to the point that he actually, I could no longer send him emails. He blocked us. And you know what he did? He gave every complaint that we had about our land being torn up and what was happening to us to the code enforcement officer to make the decision. That's as far as it went. He didn't talk to anyone else. He just gave it back to the same CEO to make the decision. And you know what that CEO told me? To stand down. And you know why he told me to stand down? Because that man right there gave that contractor a wink and a nod to do what he wanted to do. And I have all the evidence to back it up. The town knew what was happening to us, and they didn't care. And that's why when CEO Hansen came back to town, we get a violation notice on our property. Obviously, Kathy complained when we hosted our friends. Now, mind you, our friends we hosted in 2022. Kathy Plummer went to the town, complained that there's a wedding, but CEO Hansen wasn't here. Who was here?
Alex Soroy.
Alex Soroy. And you know what Alex did? What a normal CEO should do for any town. Called the town's attorney to say, is this a violation? This woman's complaining. And you know what happened? The man who was at this meeting, that ZBA meeting, which was obviously a setup, he says to him, check out the email that I talked to you about on the phone. And that email was from Todd Roma in response to Scott Dvorak saying we could never host another wedding unilaterally. And we asked for clarification because that's not what that meeting was about. And we never got a violation notice in 2022 because there was nothing that we were violating. As everyone in this town knows, you can rent your property. As everyone in this town knows, you can host private events. And we got no violation notice. When did we get one? As soon as Chris Hansen came back to town. And we didn't get it in August when we hosted our friends on our property for that event. We didn't get it then, even though he drove by. You know when we got it? One business day after Kathy Plummer yelled at us for having a Halloween party, stalked our children in the backyard, and then yelled at us. And I asked her, why are you so mean? Why are you doing this to us? And she said, the town doesn't agree with what you're doing, and you'll see about it. And one business day later, on a Tuesday at 4 o'clock, we get a certified letter from Chris Hansen telling us that we were in violation for hosting a wedding back in August. Not violation for hosting a wedding, we were violation for having a tent, a porta potty, and parking signs on our property. That's something we didn't even talk about in the last meeting. You guys flipped it to talk about that we're some big commercial business on the top of Raymond Hill. A big commercial business on the top of Raymond Hill. I mean, we hosted one wedding for a friend in 2 years. We host private events all the time. You had tons of people here the last time telling you that. That's what we do on our property. We have a beautiful place, and we are a place of gathering for this town. We do good things in this town. Todd and I have been coaching in this town for years. Our home is a place of gathering for many people, and we're open to people coming to our property. But we don't want to live in fear that every time we have an event or host a wedding or have friends over and we put up a tent or Kathy Plummer thinks there's too many people, Chris Hansen's going to send us a violation notice. It's not fair. And it only applies to us. That's the kicker, too. Because what did Chris say in the last meeting? We're the only ones that had someone complain. There were people in here saying, even Tim Davison, I host weddings. And you know what else? Chris Hansen lied through that whole meeting. He said he wasn't related to him, didn't even really know him. That's what he said. He also pointed at my husband and told my husband, Todd, I don't see a single permit in your book and in your file that you've ever gotten a permit to do any work on your barn. He was like saying to the most honest person in the room, Chris Hansen was pointing to him and saying that. And you know what? Here you go.
Building permit.
Here's all our
check that I
building
sent.
permits that Chris Hansen couldn't seem to find in our file.
It took 2 weeks for me to get that permit when Scott Dvorak started working up. And the permit is for an outbuilding that attaches to the barn. It doesn't deal with the space, it's the gathering space at all. And, you know, in Chris's response, he's trying to set it up as a safety violation. I'm like,
And then we asked, okay, so why is Kingsley Pines all of a sudden a wedding venue, right? Years ago, we came to the town because, well, first of all, they said, you can already rent your property, Jess. You can already host private events. But I said, let's put something on the books for wedding venues. There's nothing on the books for wedding venues. Let's do something, and we'll work with you. because we're getting threatened by our neighbors, and let's do it. They said that no one's ever come to them in the town of Raymond to ever ask for a wedding venue. That's what we were told. No one's ever asked for this in the town of Raymond. Yet, Kingsley Pines is a wedding venue now in the town of Raymond. And you know what we did last week? Chris saw us there. We went and we looked at the files for Kingsley Pines. We went through every single piece of paper in that file. And guess what? Just so you all know, there's not a single permit in the file for Kingsley Pines as a wedding venue. So they're a kids' camp, yeah. They put additions onto their dining hall. They added things to be a wedding venue, but there's nothing in their file that they're a wedding venue. So they became a wedding venue, yet they didn't have to go through any channels. You know what Chris said? He just grandfathered them in. But you can't be grandfathered into something if ordinances haven't changed, right? Because that's what the word grandfathered in means. And when we were going through this with Scott Dvorak back in the day and met with a bunch of people in the town like you, they said to us, you know what, no matter what, you guys, you've been hosting events on your property. If we ever change the ordinances, you'd be grandfathered in. That's what we were told back then too. And that's why when we went to the board, we were never afraid that we were never going to be able to host another wedding or have another private event on our property or rent our property, because we were just doing this because we asked for something on the books. And now we're being punished for it, big time. But Kingsley Pines, they never came to the town to say, hey, I want to be a wedding venue, what can we do? They just did it. And you know what? Then they just started advertising for it. You can Google them right now. And they don't have to sit here and get violation letters and pay thousands of dollars for meetings to talk to you. They just did it because they were a kids camp, and then they're like, you know what, let's become a wedding venue. Even though we were told in the town of Raymond, now you can't host weddings because you get a fine like we did. Oh wait, it's only us, that's right. It's only us.
Yeah.
Yeah.
You also took things like the LLC that we have, which is, you know.
So I'm going to just pause for a minute because we're not here to really dig into a lot of the details of which has already been presented to us through the letter of reconsideration. Really looking for a summary
Yeah.
of where you feel that we need to consider the reconsideration.
Well,
If we need to take it a step further, we will. I've tried to grant you as much grace as I can with regards to this, but I need to not review everything that's currently in the letter of reconsideration.
so we can't talk about what's in the letter of reconsideration.
No, we need a summary as to why we should dig into these details further.
We're telling you because of what's in the letter of reconsideration is why we should be digging into it.
Okay.
The
That
idea
the
is
facts
that
of finding
the
were
facts
not
of finding
correct.
factual.
They were not based off facts, they were based off conjecture by just seeing a tent.
And misleading. in
And
some cases.
misleading, and
You also took things like our ability to have off-street parking and turn that, like, the conversations that went on during that were just stunning because we're able to offer a safe, affordable option for people to come in and park off-street. Our road, people haul down that road all the time. And yet there are things like, there's the Summer of Love celebration. There are neighbors that park like on that road all the time and things bottleneck. The week before we received this, the week before the event for which we're getting a violation, Kathy Plummer allowed the other neighbor to park on their property to get it out of the way. So why are we being disciplined for our ability to have people park safely off the street? You know, those are one of the things that were just skewed.
And the violation was for a tent, porta potty, and parking signs. Is that a violation in the town of Raymond? And if you are saying it is, then it applies to everyone in the town of Raymond. Not just us, everyone. No one can drive by a property and have a tent on their property without Chris Hansen driving by and giving them a violation notice. No one can have a porta potty delivered. No one can have parking signs. No one. Not just us, no one. You can't single us out, which you have. You
Yep.
turned our LLC into making it where all of a sudden a commercial business. The LLC says rental, because if we choose to rent our property.
So again, this is in
The-
the documentation you provided to us.
Okay. But see, we came here today because Sandy took all our information, again. We paid a lot of money to the town. We worked hard and got everything to her on time because we were told we had this window. And all of a sudden, everything flipped the script on us. The whole town flipped it. Only because Kathy Plummer's attorney sent a letter. So I understand that you can only go by your ordinances, but we asked you what they were. We asked you for clarification, and you wouldn't tell us during that February 3rd meeting. We asked the town's attorney. He wouldn't tell us during that meeting. You told us to ask our own attorney and see what his interpretation was. Those were your words. And then you said Sandy. And we did all of that. And so, yes, you can choose now. I mean, this could all be a setup again. You could all just be like, yeah, we're just going to blow them off and send them home. That's fine. That's fine. Because we're used to it by now in this town. We just feel like, you know, we're trying to do the right thing by the town. We have paid a lot of money to try to do the right thing by the town.
And we're trying to put this evidence before you because.
And we're trying to show you this
If you-
evidence to show you what you were missing as you had it the whole time. You're like, there's something I'm missing here. And we wanted to show you there was something you were missing. You were right on. There was a lot more to the story of why we were being targeted over everyone else in the town of Raymond. So make your decision. You can choose to let us be reconsidered with our evidence. You can choose to just ignore us and say, you missed the deadline. But that's definitely nothing that we did. We did not miss a deadline.
So to be clear, yes, you did miss the deadline. However, we are moving forward as if you did not miss the deadline. We're not doing anything different now than if you had submitted the paperwork on time, just to be clear.
Yep. Thank you.
Attorney Hamer, does representation or code enforcement have opportunity to speak now, or what?
Well, it's up to you. It's your discretion if you want to let them. The code enforcement, of course, they were party to this. So if you would like to, you can hear from them. If you don't feel the need to, you're free to make a motion. It's up to you.
Would the board like to hear from code enforcement, or does that have sufficient information to move forward?
Do you have something to say? I mean, I don't know.
I don't know. Code enforcement, would you like to have something in brief?
I'll be incredibly brief. You're in receipt of the letter that we sent Chair Murch, the board. You're asking precisely the correct questions in terms of the scope of your jurisdiction. As you noted, the process you're going through now is the very process that you should be going through if considering to entertain the reconsideration. Really two things. Please keep in mind that the decision that you made, the decision that the appellants are asking you to reconsider, is your decision. We were here a month ago on a de novo hearing. All of the parties had a full opportunity to present their evidence, the best evidence that they could put forward to demonstrate why their position was correct. You undertook a robust discussion and deliberation of that decision based on the evidence that was presented to you at that time, and you rendered your decision. That is exactly the process that you needed to go through, and it's exactly the process that happened. So because everyone had a full and fair opportunity to have their arguments put forward, our position is that the board has done more than enough already. The decision to undertake a reconsideration, as has been discussed, is purely discretionary. And simply put, there has been nothing put before you that would warrant disturbing your underlying decision. If the appellants believe that the decision was made in error, they have the right to appeal that decision if they believe that they need to. Throughout this process, they were represented by an attorney. Ostensibly, he was giving them advice as to how to proceed, and they are free to pursue whatever rights they think need to be vindicated. But the decision as to whether or not to reopen the record is one that I believe you have already heard from your attorney, really is one that should be based on, was there something that did not happen that should have happened at the prior meeting? And the answer simply is no. And for that reason, we would respectfully ask that you decline to reconsider this appeal. Thank you.
So I apologize, Attorney Hamer. Again, our next step in this process.
So the applicants have come before you and they've requested that the board reconsider the prior decision. They've explained the reasons why they think you should grant the reconsideration request. The board should now discuss and make a motion whether to reconsider. A no vote saying no, we will not reconsider would terminate the proceeding. A yes vote would vacate the written decision and then allow the parties to argue about what the outcome should be.
Okay. Open it to the board for discussion with regards to moving forward with reopening this. From my perspective, we spent a good 5 hours reviewing a significant amount of information. Some of the information which was in the reconsideration is a repeat of that. Some of it is clearly clarified in our findings of fact and our decision. And other information is from four or so years ago, plus years ago, which easily could have been presented at the meeting at that time on the 28th. So I don't see a reason to reconsider this.
I think a lot of what I heard just now is not something that we even can consider. I think maybe there's a misunderstanding of what this board can and is kind of tasked to determine. Like, we can't address equity issues. It's not like we look at on a case-by-case basis. That would be a different court that would have to. We don't provide legal advice. We don't, like, we're very narrowly focused on whether or not the ordinances were violated. We can't talk, we're not thinking and discussing other venues, other potential violations or lack thereof. Those are all maybe have merit. I have no idea, but that's not just like, even if we were to reconsider it, those aren't something that like we even could address. And so, like, I actually, it's painful. Like, you guys are very passionate, and you should be, and I feel for you guys. But like, we really don't have a broad ability here to, even if we were to do it, I don't think there's a lot that we could address based off from what I heard. And so I tend to agree with you. I just don't think that. I tried to enumerate the marquee issues as you were speaking, and there's no single thing that stands out that an error that we could correct, or something that's new that that would change. I think that we're displeased with the ordinances, and we don't make the ordinances.
That's a finding wrong.
There is no ordinance.
There is, the whole
You've
point.
had-
I'm not.
You've
We're
had
not going to litigate this right now.
Right.
We've had hours already.
Of course.
Yeah, I mean, I'm thinking along the same lines as Dave and Greg. I mean, I do think you folks have been through a lot, but I don't think that changes the decision that we made at our original meeting.
Anything you wanted to add, either Tom or Fred?
I'll just say that I didn't hear really anything new on why we made an error in our facts.
You're muted, Tom.
Sorry. And I'm sorry that, they have problems with their neighbors. A lot of people in the town probably do have similar problems. But I can't see enough here to open the door again to reconsider.
You know, I think Greg's, what he says is you guys have definitely been through an awful lot. And in one way, I almost wish I knew more of what this all, back in the beginnings, I think this could have been resolved a long time ago. But in our last meeting, I remember asking, are we here for what the original one was? Are we here for the one that was issued for the last wedding you had last year? And my recall is that anything in the past we were not to look at because that had been done and taken care of, and we were looking only at the fact of the violation that you received for the one wedding you had last year. And if I recall right, and you guys may remember, I ended up asking if there was a violation, what you did was a violation of the town from that point of the violation in last year's wedding, if that was a violation for the town of Raymond. And if I recall, my answer to that was given to me was that yes, it was a violation. So, in that being said, that's why I think that we based our information on that particular thing. Nothing to do with the past that you just told, because that wasn't what we were asked to do when we came to this last meeting. So everything you say, my heart is understanding where you're coming from, and I wish that there was something that we could do for that time period that we're talking about, from the one that happened and last year, that one wedding, to now. But we have to, at least in me, and I'm looking at this, and I would like to have our attorney, Hammer, speaking, and the rest of you guys, is that we're looking at this as, was there a violation from that time period to now, right, to now. That's what we're here for. Right, that's what we're here for. That's right, that's what I'm understanding, that we're here for that. And my understanding is that is a violation. So I don't think.
Ask the town attorney that, if having a tent and porta potty and parking signs is a
We've already discussed
Yeah,
that.
I think that we've already been, that's why I said I was told it was, we were told it was. So, I mean, I don't see this, as much as my heart is, I don't see anything that's changed for that one wedding that we're talking about to now for us to reconsider. And that's, if I'm looking at it wrong, somebody please tell me, but that's what I.
So to ever have a wedding in the town, we get to
So that's not the, no. I'm going to make a motion that we deny the request for reconsideration. Do I have a second?
I'll second it.
Do we have any further discussion with regards to this?
Is there public comment?
This is not open to the public, no.
You said it was open for public.
This is not an open public, no. Not, it's open for the public to join and be a part of, but to speak, no. All those in favor of denying the request for reconsideration? David Mertz, yes.
Craig Dean, yes.
Pete Lockwood, yes.
Do I get a refund?
Tom Hennessy, yes.
Fred Miller, yes.
Wow. That's amazing. So no vote? No, we still have functions.
I would suggest that the board direct Sandy to provide written notification of the decision not to reconsider. There won't need to be any significant findings or anything like that. It would just be a letter saying that on such and such a date, the board voted to deny reconsideration, so that there'd be written, there's something in writing about the decision not to reconsider.
Does it require our signatures?
I think you can authorize her to sign it for you. It's again, it's not like the findings of fact and conclusions that would require any kind of specific adoption. This is just going to be a notice of the decision. It's up to you. If you want to assign it, you can do it. We can do it that way too.
No, just time-wise. Sandy, did you hear that? Attorney Hamer's suggestions?
Yes, I did, and I will take care of that for you tomorrow.
And you are authorized to do any signing on behalf of the board that you need to.
Yes, sir.
Thank you.
Thank you, Sandy.
So code enforcement communications, do we have any?
Nothing, there's nothing on the schedule for the 25th. We've got no appeals coming down the pipeline that I've seen. So pretty much, we're moving forward with some ordinance review stuff, and that's basically all that's going on.
Has all the ordinance stuff been through the planning board?
No, it's, the select board is going to be looking at that May, I think it's the 18th, and then they have another meeting on it later, so there's still plenty of time for public comment, but it's just, most of it's housekeeping for your end, so I don't see any issues with that, but
Okay.
no appeals coming that I know of, no big NOVs that I've sent out recently.
Okay, very good. Jason, you got anything?
No, I don't think so.
Okay, figured I'd give you a shot.
Yeah, appreciate it.
All right, need a motion to adjourn. Do I have one?
So moved.
I will second that. All those in favor, David Murch, yes.
Greg Dean, yes.
Be Lockwood, yes.
Fred Miller, yes.
Thomas, yes.
Okay, we're out.